Hi, I'm attorney Shiobhan Olivero, and we're here on another FAQ video. This video is about I didn't leave the store or the place that I was in, so how can I be charged with theft? So under Florida Statute 812.014, theft is when a person knowingly obtains or uses or endeavors to obtain or use the property of another with the appropriate criminal intent to deprive the person of the property. The language of the statute itself makes the attempt of the theft the full crime of theft in Florida. So when they interpreted the word endeavor, our Florida appellate courts held that the crime of attempted theft does not exist because by including the word endeavor or endeavor to obtain or use, the legislature showed an intent to define theft as including just the attempt itself. A completed theft crime is fully proven when an attempt, along with the requisite intent, is established. There is no requirement that the person pass all points of sale or actually leave the store or business. So for example of that, I once had a client that was charged with theft at, I believe it was something like a Dollar General store, where he took a package of t-shirts or something and put it down the front of his shirt. He had a change of heart and did not leave the store with the items. He took them out, put them on a shelf, and then left the store. They did bring him back and they charged him with theft. And it was because of the attempt itself that he was charged with theft in that circumstance, even though he didn't actually leave the store with the items. Now I want to talk about the levels of theft and what it means if you do get charged with theft in Florida. There are different levels of theft that are punishable under the statute. We have two types. We have petty theft and grand theft. Petty theft are the misdemeanor charges. And a second-degree misdemeanor, punishable up to 60 days in county jail or 6 months of probation, is a theft that is less than $100 in value. A first-degree misdemeanor petty theft, which is punishable by up to 1 year in county jail or 12 months of probation, is anything that's taken that's valued between $100 to $300, or if you have one prior theft conviction. Then the rest are felonies, or what we call grand thefts. And we have third degree, second degree, and first degree felonies. A third degree felony is punishable by up to 5 years in prison for the maximum, and that includes any value of property that's between $300 and $20,000. Or if you have two prior theft convictions, you can be charged with the third degree felony grand theft. Other items that will constitute a third degree felony grand theft is the theft of a will or some type of other testamentary instrument, theft of a firearm, a motor vehicle, a commercially farmed animal, a fire extinguisher, or any stop sign. So a second degree felony grand theft is punishable by up to 15 years in prison for the maximum. This includes property that's between the value of $20,000 to $100,000. It also includes property that is stolen that's emergency medical equipment that's taken from a facility, or property that is stolen law enforcement equipment taken from an authorized emergency vehicle, or if the property is stolen from a county that is subject to a state of emergency that's declared by the governor. Well, the property is stolen after the declaration of emergency is made and the perpetration of the theft is facilitated by the conditions regarding the state of emergency. And then finally, we have the first degree felony grand theft, which is punishable by up to 30 years in prison maximum. This includes any property taken that is valued at $100,000 or more, or if it's committed and in the process of committing that crime, a motor vehicle is used other than as a getaway vehicle, and in the course of committing that, the person damages the property of another. So if you or someone you know is facing a charge of petty theft or grand theft, contact us and we can see how we can assist you in your case. Thanks.